Good afternoon. Welcome to the first day of the Federalist Society National Lawyers Convention. My name is Jeff Wood. I'm a partner in the Washington, D.C. office of Baker Botts. I serve as the chair of the Federalist Society's Executive Committee for Environmental Law and Property Rights Practice Group. We hold events monthly, sometimes several each month, and produce publications on a wide range of topics about the intersection of constitutional governance, environmental law, and property rights. If you'd like to get involved in this practice group or any of the other Federalist Society practice groups, please reach out to Nate Kaczmarek. He'd be very happy to hear from you. Our Executive Committee's main mission is to host robust debate between leading scholars and practitioners from diverse viewpoints, and today is certainly no exception. This panel event, which is titled Defend the Constitution, Save the Planet, the Role of Public Interest Groups in Shaping Environmental Law, will examine the impact that public interest litigation has had and will certainly continue to have on environmental, natural resources, and property rights jurisprudence. I'd like to take a brief moment to recognize the members of our Executive Committee who helped to put this event together: Tony Francois, Professor Jonathan Adler, Jeff Bielert, Stephen Davis, and John Brightbill. Thank you all for your help with this. And John, I think this is your brainchild for this event, so thank you for thinking of the topic. One quick note on CLE credits. For those of you who are pursuing CLE, we remind you that to get credit, you need to sign in and sign out each day, once per day. Signing in and signing out can be done via scanning the QR codes that are on your brochures. If you're pursuing CLE and you have not checked in, please be sure to do so now using the QR code on the back of your convention booklet or on the CLE poster. If you've already checked in via the QR code, there's no need to recheck in, just to be aware. Now it's my real privilege and joy to introduce our moderator for today's panel, Judge Kathryn Kimball Mizelle of the U.S. District Court of the Middle District of Florida. A graduate of Covenant College and the University of Florida Law School, Judge Mizelle holds an impressive resume of accomplishments. She clerked at all three levels of the U.S. federal court system, including clerkships with Supreme Court Justice Clarence Thomas, Judge Gregory Katsas of the D.C. Circuit, Judge Bill Pryor of the 11th Circuit, as well as Judge James Moody of the Middle District of Florida, where she now sits on the bench. Judge Mizelle also served with distinction in various roles at the U.S. Department of Justice, including as counsel to the Associate Attorney General and as a trial attorney in the Criminal Enforcement Section of the Tax Division. And she spent time as an attorney with Jones Day. Fiercely thoughtful, hardworking, genuine in spirit, and faithful to her constitutional responsibilities, Judge Mizelle is widely recognized as a rising star in our nation's judicial constellation. I'm also privileged to know her as a friend, as well as her husband, Chad. Both were colleagues at DOJ, and it's a real honor to have her here today. Judge, thank you for your service to our nation and for moderating today's discussion with our excellent panel. Thank you.
Well, thank you, Jeff, for that very kind and gracious introduction. And it's my privilege to get to be here and moderate today's panel on this topic. I'm going to first introduce our panelists, and then they're going to each offer some opening remarks from their various perspectives, after which I will moderate for about 30 minutes after their opening remarks, and then we'll save about 20 to 30 minutes for questions from the audience. So please be thinking of what you might want to pose to them. Okay, so first, to my immediate left is Professor Robert Percival, who is the Robert F. Stanton Professor of Law and the Director of the Environmental Law Program at the University of Maryland School of Law. He previously served as a senior attorney for the Environmental Defense Fund and is the principal author of a leading environmental law casebook, which is now in its 9th edition. Thank you for being with us, Professor. Next is Mr. Damian Schiff, who is a senior attorney at Pacific Legal Foundation and leads its environmental practice group. His litigation experience includes Sackett, Part 2, right, last term, and Kontonsky v. Norton. Besides litigation, Damien has written academic articles on a variety of subjects, including the Endangered Species Act, the Clean Water Act, greenhouse gas torts, the duty to rescue, and international water law. Thank you for being with us. Next, we have Mr. David Doniger, who has played a prominent role in many landmark environmental law cases, including the original Chevron, and Massachusetts v. EPA. He's also served in the White House Council on Environmental Quality and at the U.S. EPA. He's the Senior Strategic Director of the Climate and Clean Air Program at the Natural Resources Defense Council. Thank you for being with us. Finally, we have Ms. Stephanie Maloney, who's the Chief of Staff and Associate Chief Counsel at the U.S. Chamber Litigation Center, which is the litigation arm of the U.S. Chamber of Commerce. Before that, Ms. Maloney served as Chief of Staff and Counsel in the Environment and Natural Resources Division of the U.S. Department of Justice, and has also practiced law in the Appellate and Critical Motions Practice Group at Winston & Strawn. Thank you for being with us. Okay. Yes, sure. Yes, please. I'm going to turn it over first to Professor Percival and then go down the line. We do have a diverse set of views here, and welcome hearing them.
All right, I started practicing environmental law in 1981 after clerking for a Ninth Circuit judge and Justice White on the Supreme Court. And it was just as the Reagan administration was about to come to power, and I ended up getting hired by the Berkeley office of the Environmental Defense Fund because I love California. And they said, why don't you just stay in Washington for a while? We're going to have a lot of litigation. And in part that was because of the way our environmental laws are designed. Starting with the Clean Air Act in 1970, almost all the major federal environmental laws have had citizen suit provisions. And they've had a real impact in shaping the development of environmental laws. When a study was done of the impact of citizen suits, it showed there had been 2,500 suits filed between 1970 and 2006. And the study concluded that citizen suits were the engine that propels environmental law. They were very important in getting agencies to implement the new laws, which were breathtakingly comprehensive. They granted regulatory agencies vast power to provide comprehensive protection for the environment, particularly the Clean Air Act, and that citizen suit provision was repeated in most of the other environmental statutes. When the National Environmental Policy Act was passed signed into law by President Nixon on January 1st, 1970, there was a lot of uncertainty as to whether the courts would take it seriously, but in a major decision by the D.C. Circuit called the Calvert-Cliffs case, the court said in an opinion by Judge J. Skelly Wright that these laws were just the beginning of a flood of new litigation seeking to ensure that congressional purposes heralded in the halls of Congress did not get lost or misdirected in the federal bureaucracy. In 1986, when Antonin Scalia was on the D.C. Circuit, he actually mocked that language by saying lots of laws, and particularly the environmental laws, should get lost or misdirected in the bureaucracy. And he explicitly said we should restrict and make it very difficult for environmentalists to go to court. Surprisingly, that didn't come up at his confirmation hearings because this was before we had every confirmation hearing was a completely pitched battle. In addition to allowing citizen suits against agencies to ensure they implement the laws, the citizen suit provisions allowed ordinary citizens to sue violators of the laws and environmental regulations. It wasn't until the early 1980s that that became significant when the Natural Resources Defense Council, David's group, started bringing suits in conjunction with local environmental groups to enforce those laws. A major issue that came up early on was that of standing. Who would have standing? And in the Sierra Club versus Morton case, the Sierra Club tried to establish virtually automatic standing in a case involving the federal government wanting to let Disney build the ski resort in Mineral King. It was one of those cases where you lost the battle but won the war because the court explicitly said aesthetic injuries can give rise to the kind of injury that would establish standing. Even though the Sierra Club hadn't alleged those, it was able to amend its complaint on remand. Now, I think perhaps the most significant decision in environmental law that's so underappreciated is the D.C. Circuit's decision in 1976 in the Ethel Corporation versus EPA case. The 1970 Clean Air Amendments gave EPA explicit authority to regulate fuel additives that will endanger public health. And after extremely lengthy proceedings, EPA had set the first upper limit on the amount of lead that could be placed in gasoline, because that was the major source of lead in the air that contributed so much to lead poisoning. And a 3-judge panel of the DC Circuit voted 2-1 to strike it down, saying you have to have almost a showing of common law tort injury, show a specific person that was harmed in order for the regulation to be upheld. But then the DC Circuit took it en banc, and by a single vote, by 5-4, in a decision written by Judge Wright, the court had what's probably the most powerful endorsement of precautionary regulation. And as a result, the first limits on lead in gasoline were sustained. And that ultimately led, during the Reagan administration, that President Reagan had appointed Vice President Bush to head this regulatory relief task force. And he literally wrote to industry executives saying, what regulations should we get rid of? A lot of them were his old friends from the oil industry. So they said, get rid of the limits on lead in gasoline. And it spectacularly backfired, because data started coming in that showed this almost direct relationship between levels of lead in gasoline and the rate of lead poisoning and lead in the air. And ultimately, during the Reagan administration, the data was so powerful, also data showing this was a huge environmental justice problem, because low-income and minority groups had substantially and systematically higher levels of lead in their blood, which led George Will to write a column called "The Poison Poor Children Breathe," that said, we conservative Republicans are supposed to be for equal opportunity, but if we're going to do something that's going to exacerbate lead poisoning, it's going to be a disaster. There won't be equal opportunity for these future generations. And ultimately, EPA, during the Reagan administration, decided to phase lead out of gasoline, to ban it entirely. That is widely considered the most successful environmental regulation in the world. Virtually every country in the world bans lead in gasoline. Economists have estimated that if you're going to put a price tag on the health benefits, they're something like $2 to $3 trillion per year. And I'm leading up to the modern era. Look at the court today. We have a Supreme Court that's using the major questions doctrine now to strike down the Clean Power Plan, even though EPA had no intention of putting it into effect. And they're saying there's this new doctrine that if a regulation has vast economic and political significance, unless Congress specifically ratifies it or grants the authority for it, it's gone. And in fact, the Clean Air Act, everything in it has vast economic and political significance. And I submit today, if the EPA were trying to ban lead in gasoline, that would be considered a regulation of vast economic and political significance. You're making all the gas stations get rid of their pumps that are designed to dispense leaded gasoline, and it probably would be struck down. We live at a time of complete legislative gridlock, as everyone in Washington is well aware. So these kind of doctrines, getting an activist court to intervene to strike down regulations, is now everything seems to be a major question when people are litigating against environmental regulations. One final word, I said in my prepared abstract that I was going to discuss standing, and I just wanted to mention the Reagan administration tried to keep environmentalists out of court by saying there could be no organizational standing, but what they didn't anticipate was all these industry groups with their trade associations would also be harmed if we had no organizational standing. So by a single vote in Auto Workers versus Brock, the Supreme Court rejected that attempt, and that was one case where environmentalists and industry groups were all on the same side because of the importance of being able to bring litigation. Thank you.
Thank you, Professor.
Well, thank you again for the opportunity to be here this afternoon. And PLF, where I work, was founded in 1973, right about the time, as Professor Percival was noting, that environmental law really came of age, especially at the federal level. statutes such as the 1972 Clean Water Act and the 1973 Endangered Species Act, including the Clean Air Act from 1970, impose significant new burdens. But these two statutes in particular impose burdens with the potential for steep civil and criminal penalties on activities that many people would consider just ordinary land use. So for a group like PLF interested in protecting private property rights, it's no surprise that we would become very involved in environmental litigation. And in fact, in the 50 years since our founding, a number of our Supreme Court cases have been about environmental law, some directly concerned with the interpretation of environmental statutes, and some cases dealing with the takings implication of environmentally motivated land use litigation. But I think groups like PLF have been successful in making environmental law more respectful of private property rights because we've implemented what I consider to be strategic long-term public interest litigation campaigns. Now, to successfully wage such a campaign, I think you need three things in ascending order of importance: money, legal personnel, and a judiciary that's receptive to strategically selected and timed legal arguments. So first, as to money, I think in a country of our size and wealth, money's never going to be a problem, especially for financing a public interest litigation that's interested in high-profile, high-impact Supreme Court cases. After all, the direct costs of litigating an appellate case are really not that great, and if the attorneys staffing the case are willing to work at public interest rates, I think one can easily litigate to the Supreme Court on the cheap. Second, as to legal personnel, I think it goes without saying that high-level public interest litigation has always been attractive to talented recent law school graduates, and that's as much true for right-leaning as it is for left-leaning public interest groups. But finally, again, what I consider to be the most important factor is a judiciary that is receptive to legal change. You simply cannot change the law through public interest litigation if the courts are not at least sympathetic to the underlying policies that you're trying to advance, and at the same time prepared to accept the legal arguments necessary to effect that policy change. So now, the judiciary certainly isn't static, and at any given time, courts are more or less open to moving the law in a certain fashion, and that openness depends in large part on the type of legal arguments advanced, along with the institutional constraints of the judiciary. So a public interest litigation campaign that's going to be successful must recognize that an intellectually compelling legal argument is often a necessary but rarely a sufficient condition to success. For example, I think one could plausibly argue that a lot of administrative action violates the liberty of contract, but that argument hasn't won in a century and probably will never win again. But one might also argue that that same administrative action threatens the separation of powers, that it threatens federalism, that it goes well beyond the supposedly authorizing underlying statute. Now, these two can be compelling arguments, and they're certainly less ambitious than those grounded in Lochnerism, but again, the timing has to be right. And at least in environmental law, until the late 1990s, the property rights movement's time hadn't yet matured. For example, PLF's very first Supreme Court case, which we like to forget about, Counsel versus PLF, a 1980 ruling concerning when EPA must provide a public hearing before issuing a Clean Water Act permit. It was a 9-0 loss for us, with the court concluding that the agency doesn't need to always offer such a hearing, even if there are material facts in dispute. And just a few years later, in 1986, the Supreme Court in U.S. versus Riverside Bayview Homes, addressing for the first time the geographic scope of the Clean Water Act, ruled 9-0 against the property owner, holding that the act regulates at least some wetlands, despite the fact that the statute mentions waters of the United States, not wetlands of the United States, and despite the court's acknowledgement that wetlands are not ordinarily referred to as waters. But then Justice Scalia joined the court, and I think things began to change. In fact, 1987, when he joined the court, saw PLF's first Supreme Court victory, Nolan versus California Coastal Commission, which is a 5-4 ruling written by Justice Scalia that provided property owners with meaningful protection against extortionate land use exactions. In that case, it was a demand to dedicate private property for enhanced public beach access. And over the next decade or so, the court gradually became more receptive to the separation of powers, federalism, and textualism arguments that groups like PLF wanted to make. And in environmental law in particular, this receptivity, I think, bore fruit first in the Supreme Court's 2001 decision in Swank. This was a 5-4 ruling by Chief Justice Rehnquist, which invalidated the Army Corps' assertion of Clean Water Act authority over certain abandoned gravel mining pits. And it did so by limiting the statute's reach to its textual delimitation of navigable waters, but also taking into account Congress's traditional authority under the Commerce Clause and its respect for the traditional federal-state balance of power. We at PLF took this as a signal that the time was ripe for a litigation campaign to reform the Clean Water Act. Because here was a statute that cast a nationwide regulatory net, often snagging ordinary American citizens performing everyday land use activities, that imposed significant permitting costs, that threatened significant, sometimes ruinous, civil and criminal penalties for violation of its strict liability standards, and that in its wetlands regulatory form really turned the 10th Amendment on its head, converting EPA and the Army Corps into federal zoning administrators. So our 20-year effort to reform the Act through litigation began in earnest with our 2006 win in Rapanos versus United States, continuing with our 2012 win in Sackett and our 2016 win in Hawks, and culminating this year in our second win in Sackett. Now, again, I attribute our string of successes mainly to the timely deployment of a strategic litigation plan whose underlying themes would find a welcome audience on today's bench, but that would also respect the judiciary's institutional limitations. But the arguments that won the day in these cases were essentially textualist and anti-bureaucratic. And those are two things that weren't very popular in the Supreme Court when many federal environmental laws were enacted, but they have become ascendant today. And indeed, our wins in the first Sackett and Hawks cases were unanimous, reflecting a profound shift on the court towards facilitating greater judicial review of administrative action, a shift that I think was motivated in part by a growing recognition across the bench that there is a lack of fairness and predictability in the administrative state. And even our substantive win in Sackett 2 that narrowed the scope of navigable waters under the Clean Water Act was unanimous in its rejections of EPA's preferred standard and unanimous in the court's conclusion that the Sackett's property is not regulated by the Act. Now, in conclusion, I know that there were 3 factors to a successful campaign, but there's actually sort of a 3.5 factor, which is good client selection. In Rapanos, Hawks, and Sackett, all these cases were those of small individual landowners fighting against what I call the federal wetlands regulatory complex. Each case had a good story to tell, a story that highlighted the inequities of the administrative state, and thus made the Supreme Court want to rule our way. This, in turn, increased the chance that the court would ultimately grant cert and then operationalize our Clean Water Act reform plan.
David?
So now for something completely different. So I wanted to start, I want to make 3 categories of points, but I'll start with origins. Why did Congress create citizen suits and the courts, as Bob was explaining, recognize their importance in the 70s? Well, you all know of the phenomenon of regulatory capture. The older regulatory agencies, generally speaking, are charged with regulating a set of industries or companies in a field, and there is nobody else. It's a bilateral relationship, and it tends to result in capture or accommodation to the, in many people's views, too much accommodation to the wishes and wills of the regulated industry. Well, conscious of that, in the late 60s, early 70s, when these new laws were being considered, the Congress made a deliberate decision to try to balance this by giving legal rights to the beneficiaries of the protection that these laws were intended to provide, the reduction in air pollution, water pollution, et cetera. And in order to make that, in order to give some heft or some weight to the participation by citizen groups or the representatives, you have to give them legal rights too. So we have had, from the beginning of these laws, the right to challenge final decisions on a par with the regulated industries, again, providing that we can show that we represent people who are adversely affected by the deficiencies that we're complaining about. So we meet standing requirements. And the citizen suit provisions are there to deal with delay, lapses of action by the agencies when Congress has given them express timetables or express duties that follow from factual findings. Like if you find that a certain pollutant is dangerous, then that triggers a time frame for issuing regulations about it. The effect of all this is to avoid capture, to keep the agency suspended, almost, imagine two magnets, and the agency is suspended in between these magnets and subject to pull from the industry side and from the environmental group side. So I think of what we do in that sense as representing the interests of the beneficiaries. We sometimes call that the public interest, or the interest of publics, identifiable segments of the public. And so I think that's a very important thing to recognize. Why did Congress structure the laws this way, and how have they worked out? They have kept the system dynamic and away from capture to an extent not seen in 50-year-old regimes for regulating trade or communications or other such areas. Second point, I want to take issue with the suggestion that what Damien and I are both doing is public interest litigation. I mean, you describe it, Damien, very expressly as looking to defend private interests, private property interests. And you had a telling phrase, client selection, finding the right client to be, I would guess, a poster child, an attractive poster child for these private property interests. I just don't think that's the same as attempting to vindicate the interests of the beneficiaries of the regulation, those who are, in the case of the Clean Water Act, harmed by the downstream water pollution impacts of mismanaging, from my point of view, wetlands. And the whole point of pollution statutes is that they are attempting to solve a market failure problem, that pollution itself isn't priced in the marketplace. If you can dump the pollution or into the air or into the water for free, you have no economic interest to manage it or clean it up. These laws are supposed to solve that problem. You can argue that there are other systems for doing that, but that's the function of them. And that is not in my opinion, what PLF and similar organizations do. They defend private property interests in lieu of and often with the financial backing of corporate interests that would benefit from the same doctrines. So that's my rant on that point. And you made another point, Damien, about the importance of having a long-term campaign, and getting the receptive judges. Well, congratulations, Federalist Society. You've been rather successful in, at least at the top bench, in years of late, in getting a receptive judiciary. But let's not be too highfalutin about what's involved. To me, it's clothing nakedly private interested goals in highfalutin constitution-y arguments. The term that Colbert coined some years ago is truthiness. So I would like to propose a constitutioniness type of argument. And I think the major questions doctrine and some of the non-delegation doctrines, they don't really come from, derived from purists looking at the Constitution and thinking, what's the best way to govern? No, they're arguments to clothe attacks on modern government, on the capacity of modern government. You might call it the administrative state, I call it modern government. Why does Congress enlist administrative agencies? Well, even in what I would consider the good old days of the late 60s, early 70s, when Congress was on one of its 3 or 4 big historical reform binges, so to speak, even when they were active, they had no ability to, they didn't have the bandwidth or the expertise or the foresight to understand how many different kinds of air pollutants there were going to be, with what characteristics, and coming from how many different kinds of industries, would emit them. And they wouldn't know, when science would emerge that causes something to be seen as dangerous that was previously thought as safe, or even vice versa. But they needed, for the government to function, you could not have all of these decisions made by Congress. They can't even pass continuing resolutions now. That's how enfeebled they are. And we need, if we're going to keep up with the challenges of the modern world, we need a modern government. Now, I think there are some very important democratic safeguards in modern government of this kind. One of them is a whole notice and comment system which requires that they take stakeholder input and information and consider the views, and the ability of industries, other private interests, or interests like ours to go to court and get at least some degree of scrutiny of bad decisions or corrupt decisions from the agencies. So those are really important safeguards to keep this system democratic. One last comment, Chevron. I didn't know what I was getting into when I took that case. NRDC versus Gorsuch, it was the original case, by the way. Justice Gorsuch's mom was the beneficiary of the Chevron decision. Her decision would have been struck down if Justice Gorsuch's kind of doctrines now had been in effect at the time. But Justice Stevens was doing something else. He looked at some of these same DC Circuit judges that Bob has mentioned, and he said, and it was true in those cases, there were 3 previous decisions about the definition of an air pollution source, and he said, judges, you are meddling too much in what are essentially policy decisions. They should be left to the political branches. Judges should not be importing their policy views of what's the best way to control air pollution or not into a question of statutory construction. And if there's latitude for a policy judgment left by Congress, it's the agency within bounds of reason that should have the first, should decide that question. That's why I lost that case, because they gave the agency that latitude. But in the initial years, it was embraced by all the conservative judges and scholars as the right way to go. And only in basically the late Clinton, maybe early or late Obama period, did your movement decide that this was a terrible travesty and it should be reversed as violating separation of powers and God knows what else, and the role of judges. These are all rationalizations for a discomfort that the conservative movement has acquired when policy judgments are made by more liberal governments. Think about whether you want the same constraint if there are ever conservative executive branches again. So I would, I don't know what to expect in Loper Bright and Relentless. Relentless would have been the absolute best name for a case of this kind ever. But the question I would pose is, if one is going to change or wholesale abandon the Chevron doctrine, what will be the new rule? Will it be judges should go back to inserting their policy judgments? Do we want Judge Kaczmarek in Texas to be second-guessing the FDA on the safety and effectiveness of the morning after pill? You might, I don't. And do you want the randomness of outcomes that comes from the selection of judges in different districts? So I think we need to keep policymaking in the hands of political branches and I say that even knowing that there are times like in the Trump administration and the Reagan administration where the policy direction of those administrations was completely uncomfortable to me, but I still think it's better. So that's why we filed a brief in Loper Bright saying we're the party that lost in Chevron, but we think you should be very careful about opening the floodgates to what Stevens was trying to shut down, which is lower court policy making in the guise of deciding questions of law. So I'll stop there, and I'd love to engage with you all on this.
Thank you, David. Stephanie?
Thanks, Judge. And if David has those thoughts about PLF, then I can imagine his thoughts on the chamber. So I'm looking forward to hearing those. I just want to start with some words of thanks to the Federalist Society and my fellow panelists for today's conversation. It's really a pleasure to be here with you all. As many of you in this room know, the U.S. Chamber Litigation Center brings direct legal challenges against federal agencies for their overreach. We fight for business and free enterprise in the courts. Bringing lawsuits is one of the most important tools we have to combat the enormous regulatory burdens that businesses are facing today. If we can knock out these regulatory obstacles, then we clear the way for businesses, large and small, to keep doing what they do best. So we're taking that responsibility seriously. Since last summer, we filed 8 new lawsuits. Just today, we sued the NLRB over their joint employer rule. We've successfully sued EPA and the Army Corps of Engineers over their WOTUS rule. We've sued the SEC twice. We've sued the state of Connecticut. And we've sued the FTC, the CFPB, and HHS. So quite a bit of the agency alphabet soup. I'd like to start off this afternoon by telling you just a little bit more about our energy and environment litigation, and then explain how that fits into our broader fight against government overreach. As a historical matter, most of the litigation center's regulatory challenges have involved energy and environment issues. Currently, we have 10 pending lawsuits where EPA is a party, although quite a few are in various stages of abeyance. But we regularly litigate perennial issues under the Clean Water Act and the Clean Air Act, such as the various standards EPA sets for national ambient air quality, EPA's emission standards for power plants, and the definition of a waters of the United States. At least on WOTUS, we've recently managed to secure some real clarity around the text of the Clean Water Act. For decades, WOTUS regulations have been the subject of regulatory and legal ping pong. The agencies tasked with enforcing it and the courts tasked with interpreting it have wrestled with what exactly is a WOTUS. As a result, businesses of all sizes, along with individual landowners, have been put in a precarious situation, subjected to vague and changing rules that often require them to hire expensive experts and consultants that will advise on whether they need permits to use their own land. If they guess wrong, as Damien mentioned, they face potentially severe, even criminal penalties. PLF's litigation on behalf of the Sacketts and unanimous decision in the Supreme Court demonstrates those exact difficulties and has helped to define the statutory provisions that limit the geographic reach of the Clean Water Act and thereby limit EPA. But PLF has not had to litigate alone. Earlier this year, not content to wait for guidance from the Supreme Court in Sackett, the Biden administration chose to finalize a new WOTUS rule. The chamber led a coalition to challenge that rule. We partnered with the Kentucky Chamber, along with the Georgia Chamber and other associations, and we coordinated with the state of Kentucky to file a lawsuit in the Eastern District of Kentucky. Our lawsuit highlighted the rule's impacts, particularly on small businesses. For example, we described mining operations, an aluminum factory, and a Kentucky-based pig farm that would be forced to expend time and resources assessing whether their activities implicated the new, vague, multi-factor standards of the WOTUS rule. Given the immediacy of those harms, we also moved for an injunction. In May of this year, the Sixth Circuit granted us an injunction pending appeal that prevents EPA and the Army from enforcing the rule against members of the chamber and our coalition partners. Given the various definitions of the rule that now apply amongst the various states, EPA has posted a nationwide map which shows the particular WOTUS rule that applies in a particular state. And our favorite feature of the map is that it expressly recognizes, no matter the state, the members of the chamber and our coalition partners are protected by our injunction. So this sort of environmental litigation remains important. But today, when we think about the agencies and the rules that are making headlines and keeping general counsels up at night, it's rules coming from the SEC, FTC, CFPB, even the Federal Acquisition Regulatory, or FAR Council. The present administration has increasingly empowered executive agencies to stray far outside their areas of expertise resulting in a host of legally vulnerable regulations. For example, you have the SEC trying to set climate action and human resources policies, while you have the FTC trying to set workforce policy by proposing to prohibit non-compete agreements nationwide. This administrative mission creep is troubling. Agencies are increasingly asserting power beyond what Congress could reasonably be understood to have granted. Whatever you think about the underlying merits of this social agenda, such agency actions raise significant separation of powers concerns. Simply put, it's a question of who decides. Businesses value predictability and stability in the law. Congress promotes that kind of regulatory environment when it appropriately exercises its Article I powers, enacting statutes that clearly define legal responsibilities. The role of the executive and its administrative agencies is to execute those clear statutes, making relatively minor, gap-filling interpretive judgments. And the judiciary must say what the law is, using traditional tools of statutory construction to faithfully apply statutes as written. Thankfully, from district courts to the Supreme Court, we have a judiciary that seems inclined to do just that. At the same time, we're seeing a federal regulatory agenda more aggressive than ever. We're seeing a judiciary more inclined to curb it back. We have courts that are skeptical of agency mission creep and that have expressed a willingness to enforce those structural limitations so that each branch of government stays in its respective lane and administrative agencies do not impose regulatory burdens that exceed lawful bounds. Now is the time to make favorable precedent. This is an environmental law panel, but as all of you know, so much of environmental law centers on administrative law. If we can develop favorable administrative law in any context, it will give us real leverage in our fights against EPA and other agencies. By way of example, I'll mention just two recent wins we've had reining in administrative overreach. First, just last month, we set favorable precedent for arbitrary and capricious challenges. We handed the SEC an important legal defeat by scuttling the agency's stock buyback rule. The SEC in May finalized a rule that required public companies to disclose their daily share repurchases and the reason for buying back that stock. We sued, arguing that the SEC had violated the APA by failing to quantify the rule's costs and benefits. The Fifth Circuit agreed and skewered the SEC for failing to substantiate the rule's purported benefits. The panel remanded the rule to the agency to correct its defect within 30 days, and we're pretty sure it won't be able to. Second, earlier this year, we developed helpful precedent on when an agency manual update can be challenged as final agency action, and won on major questions doctrine. This was in our challenge to the CFPB's update to the unfair, deceptive, or abusive acts or practices section of its supervision and examination manual. The district court found the manual update adopted a new binding legal position on UDEP prohibitions that made it final agency action. The court then agreed that the action exceeds the CFPB's statutory authority, applying the major questions doctrine and finding no clear congressional authorization for the vast economic and political power claimed by the CFPB. As a result, the court vacated the manual update and enjoined the CFPB from pursuing any action against any of our members based on the update. Going forward, these lawsuits are really the tip of the iceberg. We're expecting many more rules to be finalized this year and next. In fact, we keep a running list of rules to challenge as they're proposed. We won't be able to sue over all of them, but we expect to sue over some. A few are the familiar issues I mentioned at the top, the PM and ozone NACs. Others are new, such as EPA's efforts to designate PFAS and PFOA as hazardous under CERCLA. We regularly talk at the Litigation Center about this being an important moment, both because of the need to push back against much of what the administrative state is up to, but also because this is a court that's particularly inclined to curb administrative overreach. And I'll flag just two potential wrinkles in closing. First, in many of our lawsuits, we partner with state and local chambers to secure venue in the best courts for regulatory issues. But the venue provisions of the Clean Air Act require that nationally applicable EPA actions be filed in or transferred to the DC Circuit. And venue matters, particularly for litigants who are looking to avoid reflexive judicial deference to administrative agencies. So we may see venue constraints slow agency accountability in the lower courts, even as we can achieve real success on the Clean Air Act in the Supreme Court. Think West Virginia v. EPA. Second, many of us have referenced major questions doctrine, and at least from my perspective, it remains an obviously powerful tool to fight extreme agency overreach. But not every example of agency overreach will present a major question, and there's a risk to overusing the doctrine and potentially diluting its force. The Supreme Court has done some real work in fleshing out the major questions doctrine between West Virginia v. EPA 2 terms ago, and then last term when it applied the doctrine in the student loan cases. But the doctrine is still very much unsettled in some important respects. Justice Gorsuch's concurrence in West Virginia laid out a non-exclusive list of triggers for the doctrine's application. Justice Barrett's concurrence in the student loan cases framed the doctrine as an interpretive tool rather than a substantive canon. So we're seeing some differences in approach amongst the justices. That's all to say that when we have litigants raising major questions doctrine as a matter of course rather than as strategically appropriate, we increase opportunities for courts that are hostile to the still developing doctrine to narrow its application and undercut its effectiveness. We need to be strategic in its use if we hope to realize its full deregulatory potential. Thank you.
Well, thank you all for those opening remarks. I want to start our conversation with something that each of you, I think, has touched on, which is the foothold of any citizen supervision is standing under Article 3. And my question is, what is the future of that litigation? Has the court solidified the injury in fact aspect of standing such that that's not going to be a pressure point in the law going forward? Is it looking now to something more on the traceability prong? Or is the law fairly stable in these citizen supervision plaintiffs?
Well, I can start out with that one. I think actually when the Laidlaw decision came down 7-2 with only Thomas and Scalia in dissent, it basically sent a signal that to establish standing, you shouldn't have to show that you could win a common law tort action because of the environmental violation. And now that Justice Scalia is not on the court anymore, and Justice Gorsuch has a reputation of not having been a real bear for keeping people out of court, it's kind of calmed down a bit. But the case I would flag is the Texas Citizens Lobby case that's the Fifth Circuit is hearing en banc, because that was a case where citizens living near an oil refinery alleged thousands of Clean Air Act permit violations. And it's been a long struggle over almost a decade. At first, the court found some violations, but refused to even penalize them because it liked the refinery. That got reversed, and then they found something like 1,000 violations. A fairly substantial multi-million-dollar fine was levied, but then it went back up to a Fifth Circuit panel, and ExxonMobil is arguing that for each of the 1,000 violations, you have to find a specific plaintiff who can say they saw the violation, exactly how it affected them. That's madness. That's like going back to, well, let's just scrap the permit requirements and go back to a common law system where you have to bring a common law tort suit and prove that it's more probable than not that a particular violation caused you injury. If the court starts becoming sympathetic to that, it's going to make it virtually impossible to enforce some of these environmental laws.
That was the case, actually, I was thinking with regards to the traceability. Is that something that's being pushed in other courts across the country that you've seen?
That's the one that I'm most aware of.
Well, the one reflection I have is on Massachusetts versus EPA. And I know there's another panel about special solicitude and so on. I think if you actually read the Stevens opinion functionally, he found that Massachusetts had concrete injury, loss of beach, traceable to sea level rise, traceable to climate warming. If anything, in the, what is it, it's 15 plus years since then, the climate science has gotten tighter and tighter and tighter. And I actually think it would be, it's very plausible that all the judges would find, oh yeah, that problem has become real enough that we can see the connections and the injury traceability and remedy, and would uphold that. I would note that though there were state and public interest groups in that case, the holding on standing went only to Massachusetts. There's a DC Circuit decision by Chief Judge Srinivasan, NRDC versus Wheeler, which held that in a challenge by NRDC to a regulatory relaxation on the control of chemicals called HFCs, hydrofluorocarbons, that we had demonstrated the contribution to their contribution to warming, the impact of warming on climate and the exposure of specific individual members of ours to those kinds of damages. And he upheld NRDC's, and by implication other public interest groups, standing to bring climate-related challenges. Now, that's not the Supreme Court, but it's an important decision. You know, I just think you have to get real about this. If the basis for denying standing is actually denying climate science in that case, then that's not a very sound legal proposition. Now, it's our burden, it was our burden, to establish that science, and we did. We had expert affidavits from some of the nation's top scientists for each step in the chain. And, you know, I think I would be very upset if standing was used, you know, again, to try to stop citizen groups who represent the beneficiaries of these laws from having legal rights. We got to keep, it's functionally very important to keep the administrative agency suspended between the regulated and the beneficiaries of the regulations.
If I could add just a bit to that, I'm in sympathy with what David has just said, because in his early remarks, too, about his noting that Chevron at one point was considered sort of a conservative doctrine, and I think we've realized that it's not really a conservative doctrine, it's just a bad doctrine.
It's a neutral doctrine.
I think the same thing is true of standing. I mean, really, the sort of canonical theory of standing, injury in fact, and traceability, and I mean, all that's made up. That's essentially sort of a prudential common law gloss that I think perhaps a reckoning is going to happen such that, and quite right, I think David is right. I think that it's not appropriate for citizens who clearly have an injury that nobody would say this is made up, that we're just sort of going through the motions. Those citizens deserve a hearing, and for what it's worth, look at, you know, almost all states recognize some version of citizen standing. It's not as if we have sort of tyrannies going on or you know, kangaroo courts in the 50 states. So I think that it is appropriate to reassess standing. Now, I will say there's been some interesting scholarship recently about whether statutory standing, sort of the zone of interest test, needs to be reexamined, and whether maybe some APA cases that the challengers might need to show something more than what they have under the data processing test. But setting that aside, as a constitutional matter, I would welcome a reexamination of that.
And I'll just add that the Chamber Litigation Center, to some extent, I think probably has a different perspective on standing than Damien does, and that some of my other friends up here do. You know, as a trade association, we file lawsuits on behalf of our members. So we're suing the regulators on behalf of, to use David's phrase, the regulated industry. As part of that, you know, there is some division amongst the circuits about the need to disclose and identify a particular member who has specifically alleged harms. And so even as, you know, we're seeing the Supreme Court possibly be reconsidering the special solicitude given to states for their standing, part of what we're doing at the Litigation Center is thinking strategically about whether there is or should be or deserves to be a need to identify particular members, right? Obviously, it's difficult to be a company, a business, who's raising your hand and challenging the regulators. So do we need to be identifying by name members who are impacted, or is there First Amendment associational protections whereby we can proceed, setting out the harms that members are facing, but not needing to identify them by name. So I think, we've seen this Supreme Court have very robust approaches to the First Amendment and associational protections. We saw that in Americans for Prosperity. So it'll be interesting to see how the court's, what seems to be reconsideration of standing doctrine, will come up against its robust First Amendment doctrine.
Okay, Stephanie, you mentioned from the Chamber's perspective there's concern about agency mission creep. David, you talked about, I think, the opposite concern of agencies becoming captive to the industry that they're regulating. I'm wondering what concerns, Article 2 or otherwise, do any of the panelists have with things such as consent decrees in this space? Is there any sort of collusive aspect between the potential regulated industry and the agencies?
Can I start on that? Well, where do we use consent decrees? Let's take a typical case where an agency has a deadline specified in the statute, either a calendar date or a date that, a clock started, let's say, 8 years earlier, and then the deadline has expired, for revising or issuing some rule. It's a pretty clear legislative mandate to do something by that deadline. And usually in those cases, you walk into the court not with a brief, more or less, but with a calendar. And you say, and everybody concedes, the deadline has been missed. What is the remedy? If it goes to the judge, and both sides are arguing, the agency is going to say, I need 2 more years, and we're saying it could be done in 6 months, and so on. The judge can decide. Often, the parties can work out an agreement a settlement that they would agree to. Normally, settlements are favored as a means of avoiding litigation, and I think that's totally normal. One thing that was added, I can't remember if it was in 77 or 1990 amendments to the Clean Air Act, was a requirement that those kinds of settlement agreements, whether it's a settlement agreement or a consent decree proposed, that those should be aired in a public Federal Register notice for comment by anybody else who's affected, so that in the case of so that the judge in the case could decide whether there's some reason why this resolution that's been worked out by the main parties in interest shouldn't be followed. And I am aware that it's very standard to do that, and I think it's very infrequent that comments are filed opposing those deadlines. It happens, and I think it's even more infrequent that the judge says, this time frame that the agency and the plaintiff have worked out is some reason or other unacceptable. But that's the role the judge can play if a third party has come up with a really good argument. I don't think it's collusive in any sense other than that all settlements, all peaceful resolutions of what start out as lawsuits can be described as collusive. So I reject the notion of the criticism of sue and settle and collusive agreements. Congress created these deadlines and also created the authority for citizens who are legitimately affected to go to court to seek to enforce the deadlines when they have been missed. And that's a very important function in the law.
So just, David, one response, which is, I think you were critical of Damian's characterization of PLF as a public interest law firm, as opposed to, from your perspective, litigating on behalf of private individuals. To me, to some extent, these sorts of consent decrees are analogous in that you have activist environmental groups that are suing agencies because they think that their priorities about what ESA listing determinations should be, for example, are, should take priority over what the public representation in the form of the agency, what that thinking is. So just one point of observation.
If the agency truly believes that, I'm making this up, there's 10 things on their list, and the plaintiff has brought the 10th least important thing, it will go first to the plaintiff and say, I've got 9 things that are more important. Don't you agree? And if we don't agree, then it could end up going to a judge, and the judge can weigh the competing priorities of the agency, those kinds of arguments, in deciding what deadline she should issue.
Professor, you've written about this, I think. Do you have any comments to add?
Well, I was on a panel 2 years ago at this convention about it, and I urge you, watch that tape, because it was a lot of fun. One of the things I mentioned, or the subject there was this interference with state and local governments. But just look at my own city of Baltimore. I live in D.C., but I teach in Baltimore. The Baltimore police had a lot of corrupt cops who were arresting people in order to rob them, especially suspected drug dealers. And fortunately, a lot of them are in prison now. But it was only the federal consent decree that the Baltimore Police Department entered into with the Justice Department that has really started the reform of that very corrupt department.
Several of you have mentioned the major questions doctrine. What role is that going to play going forward in litigation? From both sides of the aisle, perhaps.
A big role.
Yeah, probably a big role. But I think I agree with Stephanie that it's a mistake for the litigants to just shout major questions in a crowded theater and try to stampede, the audience. I've seen some really laughable efforts. There's one case involving a company that makes defeat devices to replace the pollution control devices in cars, or defeat them, so that the cars will run more like race cars. And they claim, they sort of shrouded themselves in, these are the most amateur second, third, fifth tier NASCAR people in the world. They tried to make this into a major question because somehow this would interfere with the ability of NASCAR people to enjoy car racing. Well, it didn't get any traction.
Well, and my understanding is that in his disbarment proceedings in D.C., John Eastman is claiming it's a major question whether he can be disciplined by a bar association, which shows you. And now that Congress is in such gridlock, the consequences of ruling that something's invalid because of the major questions doctrine is all the work the agency put into carrying out the law is gone. And the fact of the matter is, if you look carefully at the environmental laws, they were intended to have vast economic and political significance. Supreme Court unanimously, in the American trucking case, rejected a non-delegation challenge to the National Ambient Air Quality Standards, which are what guarantees healthy air quality for the entire United States. You can't imagine anything with greater economic or political significance. But that's what the statute expressly gives EPA the authority to do, and it's so essential to why our air is so much cleaner than in other countries like China that we're the envy of the world.
So I'll just add that to me, legislative gridlock is not statutory authorization for agencies to pass sweeping regulations. But on major questions doctrine, I noted that we've brought quite a few lawsuits recently. We're going to bring quite a few more. We're approaching the doctrine pretty strategically. So, for example, in the lawsuit that we just filed today against the NLRB over its joint employer rule, that's a pretty perennial issue that we litigate. We didn't raise it there. There will be others like that where we've litigated it in the past. We'll continue to litigate it in the present. And it's just not going to inform those lawsuits, but there are other big ones where we're seeing agencies do very new things. Think a lot of what the SEC is doing, where we're thinking strategically about deploying major questions doctrine there.
I would just say one last comment about somebody mentioned West Virginia. I think you did. It's important to note that while the court struck down the design of the Clean Power Plan, it contrasted that quite favorably with the way that EPA had regulated under this industries under this provision before. And that was not creating a major question. So there's an ongoing rulemaking to address power plant carbon emissions again, and EPA is trying very hard, and I think successfully, to stay within the pathway that the Supreme Court said doesn't implicate this doctrine.
If I could just make two small points. One is I think that we should also pay attention to what might be sort of per se applications of the major questions doctrine, which I think of now as the federalism canon as being, which Justice Gorsuch noted in his concurrence in West Virginia, and which was employed by the majority opinion in Sackett. And I think they'll be more prominent in part because they have fewer moving parts. You don't need to show as much. They're a little more established, but they still have the same clear statement burden placed on the agency. Secondly, I would say in addition to groups who want to use the major questions doctrine, I would also urge caution on the enforcement zealousness of certain environmental groups and citizen supervisions. Because of the major questions doctrine, and I would draw everyone's attention to a Fourth Circuit decision from just a few months ago, in which an environmental group sued a bunch of fishermen saying that when they trawl for shrimp off the coast of North Carolina and they throw back some bycatch, which is already federally regulated under the Magnuson-Stevens Act, that's a discharge of a pollutant. They've taken the fish out, they don't need these fish, they throw it back, that's a discharge of a pollutant. And the Fourth Circuit ruled against the environmental citizen suit groups because, in part, of the major questions doctrine, that if the Clean Water Act were to apply to federal fisheries policy, it would essentially make it unworkable. And that would be a really big deal. So I do think that it goes both ways in terms of being careful not to press the law one way or the other in a non-strategic way.
Also, it might be worth thinking through whether in a future conservative administration, whether the deregulation of lead in gasoline or something of that magnitude could be considered a major question because of all the harm it inflicts and the financial value of the harm that it inflicts.
Well, thank you all. I promised I'd leave time for questions, and I think we should turn to the audience at this time.
So imagine the world where Loper Bright comes out and says Chevron is no more. We're going to have de novo review or Skidmore or something like that. How does the major questions doctrine play in a world without Chevron, where there is no interpretation of statutes anymore by agencies in that way? Is there still a place where it's going to have a key role?
Well, just a quick thought. I mean, if the agency isn't interpreting the statute, if we go to a full-on, it's going to be the judges who interpret the statute. Then the judges will determine what the scope of the statute is, and then either in that case or future cases, the question will be whether the agency is acting within the scope of that. So I imagine the same kinds of arguments about scope of authority or whether the agencies are overreaching would be made, even if the let's call it first order clarification of what the statute means is by whatever random judge happens to be the one selected.
But I mean, the agency will still have to interpret the statute. The question is just, will they get deference? And if you overturn Chevron, then they don't automatically get deference.
But they'll still be offering their advice.
Does the court agree?
Yeah.
I just add on that, too, that Cass Sunstein has an article about how there are two major questions doctrines and how the one is just simply Chevron displacement and the other is more substantive. And so if the major questions doctrine is more of a substantive canon, then I think that that Chevron's overturning won't have any impact on it. And I do think that that's essentially what the canon is doing now.
Yes, sir.
Roger Pilon, Cato Institute. David, I was struck by your rant, as you rightly called it, in which you suggested that there were black hats like Damien and Stephanie who were promoting these hoary private interests as against folks like you with the white hats who are interested only in the public interest. I wondered why you use such a political characterization of this when really so many of these cases you've been talking about are simply rule of law questions in which reasonable people can have reasonable differences about health and safety, and just as environmental law is a species of nuisance law writ large, you're going to have health and safety lines drawn. And that falls into two categories, namely the health and safety kind that you've mostly talked about, as well as the regulatory takings area, like in the Lucas case, where the question is whether a statute that, for example, is justified for promoting tourism can take all but the last use that is available to David Lucas of his property. And there you can simply say that those public goods are perfectly available, you just got to pay for them. So these are rule of law questions. They're not simply political decisions as though that's all that was at issue.
Well, I confess I haven't thought about the case that you mentioned.
David Lucas?
I don't know anything.
Lucas v. South Carolina,
Right. I don't
Coastal
know.
Council.
Okay, so I'm confessing I can't speak to that. But and I didn't use the phrase white hats and black hats.
No, I did.
And I think I got differentiated from Damien, so I'm
yeah.
not sure if I should take that as a badge of
So
honor.
the only point I'm making is that I hear it in Damien's self-description of what PLF's and his own objective is. It's to seek out and find private property interests and represent them. Now, I suppose you can have a theory that the protection of private property is fundamental to the public, is an essential public interest foundation to our rule of law and in our governmental structure. Fine.
It's also a constitutional right.
But what do you do about pollution? What do you do about the real impacts that happen that are not captured and disciplined in any market system? That's why we have these laws, because the tort system was neither taking these questions to judges in individual tort cases was an inefficient and really, it put judges in a position where on any given day you'd have to learn the science of PFAS or whatever chemical. They don't know about this stuff. And Congress found it the right thing to do to enlist agencies in order to capture that expertise and that capacity that the tort system simply failed to deliver.
And pollution is a threat to property rights. And just to say a word, in praise of Damien's group, which I don't do a whole lot, there was the case of Arco versus Christian, I think in Supreme Court about 5 years ago, where the question was, could Montana's state law that allows property owners who've had their property polluted, like the smelter that just had vast pollution around it, could they recover restitution damages? And it was very interesting. Washington Legal Foundation filed a brief saying, we're with Arco all the way, it's preempted by CERCLA, but the Pacific Legal Foundation filed a brief on exactly the opposite side, saying it shouldn't be preempted, that property owners should be able to have this additional state remedy because their property's been polluted. And I thought that was a great job.
If I could just add, just real brief, I don't think anything that we did at PLF has resulted in the rivers catching fire. But I can assure you that stopping the Sacketts, for example, from building their home did not prevent any other river from catching fire. It's really more of a question of balance. And I think you read, for example, Justice Alito's majority opinion in Sackett 2. His very first sentence almost is that the Clean Water Act, basically nobody disagrees, has been a success. And rivers aren't catching fire. And I think that's great too. But at some point, though, there has to be a balance between environmental regulation and making reasonable use of your property. And it's my view, and I think it's PLF's view, that the administrative state in the last several decades has got that balance wrong. And now the Supreme Court has sort of appropriately rebalanced things. So that really is, it's not so much it's not as dramatic as it might otherwise appear.
Mr. Gruev?
Thank you. Thank you all. Question about Clean Water Act citizen suits. So an important limitation on those suits is the diligent prosecution bar. I think pretty much every circuit that has dealt with that issue has concluded that there's some kind of presumption of diligence on behalf of the government when it does something like enters into a consent decree, but none of them are very sure where it comes from. Doesn't seem to be in the text of the statute. Some of them ground it in Gwaltney, some of them ground it in like the presumption of regularity. So wondering first if you have any thoughts on how much deference courts should be paying to executive branch determinations in contexts like the diligent prosecution bar, and then second and relatedly, the remedies in these kinds of suits are oftentimes public remedies. Like one Clean Water Act remedy is a fine paid to the public fisc. Are there Article 2 constitutional concerns that should color how courts interpret statutes like the diligent prosecution bar that limit citizen suits?
Well, you have to draw a line somewhere, but the case where it was easy for everyone to say there hadn't been diligent prosecution is Laidlaw, the very case where Justice Scalia's doctrine of standing got stuffed by a 7-2 majority. There was a case of the Friends of the Earth had sued this polluter for hundreds of Clean Water Act violations, and the minute they got the notice of the potential citizen suit, they went to South Carolina authorities and said, please sue us to preclude the citizen suit. And South Carolina authorities said, oh, we don't have the time or money to do it. So they said, we'll draft your complaint for you. We'll pay the filing fee just so we can preclude the citizen suit. And the trial judge quite properly said, that's not diligent prosecution. That's just an effort to try to defeat the citizen suit because you have such a cozy relationship with the regulatory agency instead of honoring your permit. Now, your second question was?
Article 2.
That was Scalia claimed citizen suits were unconstitutional, and yet, our very first Continental Congress adopted qui tam provisions that allowed ordinary citizens to stand in the shoes of government to recover judgments on behalf of the government. And so the rest of the Supreme Court pretty much, I think that's kind of a dead letter now. Citizen suits are so well established, and they have been since the early days of the Republic.
I'll just add, you mentioned qui tam suits. If folks read Polanski last term, at least in the False Claims Act, the court seems open to reconsidering the constitutionality of qui tam lawsuits. So I think, like major questions doctrine and standing doctrine, this is another area where we're seeing this court think critically and deeply about questions that, to some extent, have seemed longstanding.
Yes, sir.
Yes, thank you, Frank Shepard. Just following up ever so slightly on, I think what the first question was, it strikes me that the, with respect to the Chevron doctrine, one of the basic propositions is that if a judge can read that blessed statute and understand it, he or she should not look at or should not defer to what some agency unelected person has to say. Don't you think, Mr. Doniger, that that's a pretty valid criticism of the Chevron doctrine?
Well, what you're getting at, I think, is the criticism is about Chevron Step 2. Everyone agrees that Chevron Step 1, read the law, see if it's clear, use all the tools of statutory construction, text, context, structure, maybe even legislative history, to figure out what that statute means. That is the first obligation of the court to grapple with that. And if the court concludes that the law is clear, whether or not that's the agency's position coming in, or sometimes it's our position, the law is clear and the agency has not followed it. That's the first inquiry, and that should be robust. And in our brief, we said we have no problem with the idea of reminding the lower courts that you need to grapple with Step 1, with the Step 1 question. And it's only if you see in the statute that the Congress has left a range of policy space for the agency to choose among, a range of reasonable policy space to choose among to solve the problem that they saw in a general way, in a way that's particular to a particular pollutant or industry, better than some other way. That's when you defer. Now, is there a criticism out there that some judges are too quick to say, this is to use a Scalia phrase, argle-bargle, and I don't understand it, so I'll defer. I'm sure that's true, but it's not what we are trying to get judges to do.
Yes, sir.
Yes, hi. So we've talked about how the citizen suits were implemented to balance against regulatory capture, but with Chevron deference in place, and the deference being given to the administrative agency, do we see that these policies are in contrast with each other, where the administrative agency might be captured by the regulated, and then they're deferred to? So, is the citizen suit hurt in that way, and which should be favored if so?
Well, I think of the Chevron deference in the way I just described as the residual after you've checked to see whether the statute really is clear and specific. The Chevron deference there is a neutral principle, and it'll be used it was used originally by the Reagan administration, in my case, to cut back the scope of a major new Clean Air Act provision by 90%, just by changing a definition. I thought that was bad. And it's been used by, let's say, the Clinton or the Obama and Biden administrations, less so now because they don't make explicit appeal to the Chevron deference. But their interest is to try to do more with this statute, not less. Fine. They still have to be subject to judicial review, and if the law clearly doesn't allow what they said, how they interpret it, they should lose at step one. I don't think the major question doctrine was needed at all, because step one and step two do it. And just one quick, I've never understood Chief Justice Roberts' opinion in, I think it's King v. Burwell, where he said, we're not going to defer, but then he went through an analysis of what the statute means. And instead of calling that a step one analysis, because he read the whole statute, how all the parts fit together, he concluded that if the federal exchanges didn't apply, I'm not stating the issue correctly, but the law would fall apart, it wouldn't work, and thus he upheld the government's position, not as a matter of deferring, and not even explicitly as a step one question, but he framed it as like, it's for me to decide what it's going to take to make this statute work. I thought he could have reached exactly the same conclusion at step one, and I don't understand why step two figured into it at all.
Well, but I guess once we get to that step two and deference is possible.
We lose a lot of cases at step two.
Well, yeah, but what I'm asking is, does the deference to the administrative agency cut against the interest in having citizen suits and the protection against regulatory capture?
Well, I don't know the case that these two guys were discussing, the fisheries, the clean water versus fisheries case, but from the description, it sounds like I can't quarrel with that outcome. This mission was given of regulating the fish catches is given to the National Marine Fisheries Service, and this was a sort of clever sideways effort to get more, to treat dead fish as pollution. When they're in my refrigerator, they are pollution. And, you don't need big new doctrines to reach sensible outcomes.
I think we have time for one more question.
Thanks everyone for a great panel. My question is, what role, if any, does the limited and enumerated powers structure of Article 1, Section 8 in the original scope of the Commerce Clause have to play in the future of this litigation space, or should it have any role to play in the future of this litigation space, both on the Save the Planet side and on the Protect the Constitution side?
Well, I would direct your attention to the concurring opinion by, I guess it's Justice Gorsuch and Thomas in Sackett, suggesting that, well, wow, the Clean Water Act may only be justified by the ability of Congress to regulate navigation and not commerce. It is in fact the case, the U.S. is one of the few major countries that doesn't have any reference to the environment in their constitution. Now that's because most countries have updated their constitutions in comprehensive fashion recently, and we have the oldest written constitution, haven't amended it much, but the Commerce Clause has proven to be the basis for upholding all the federal regulatory authority that's used in most of the environmental statutes. And in fact, the court has had no trouble with that, even in the context of endangered species, where if they're so endangered, they're not going to have great commercial value or be crossing state lines. The idea being, like Justice Scalia mentioned in Gonzalez versus Raich, that if the only way you can have a comprehensive regulatory program is to regulate even purely intrastate activity, Congress has the authority to do that. Now, when I was clerking on the court, we had this tradition, chambers all ask each of the justices out for lunch, and when we had lunch with Justice Rehnquist, we asked him what his favorite decision was, and he said Gonzalez, what was it? It was National League of Cities versus Ussery, where the court had struck down the application of federal wage and hour laws to employees of a governor's office. And we said, why is that important? And he says, it's an agent in place. And he outlined he had a clear agenda that one of the things he wanted to accomplish on the court was cutting back on federal regulatory authority. Unfortunately, National League of Cities versus Ussery got reversed by the Supreme Court a few years later when Justice Blackmun said it's kind of hopeless for us to draw the line of what is a traditional state function and what's not. But in his Lopez decision, he fired the shot across the bow of Congress, and then subsequently in the Morrison decision involving the Federal Violence Against Women Act, the court, in what I think was largely symbolic decisions, said Congress has gone too far without drawing the necessary statutory connection to commerce. But in the environmental area, everything has been upheld. If you want to have an activist court wanting to essentially repeal the environmental laws because of some new constitutional interpretation, you can't use the Commerce Clause to uphold them, which was suggested in the concurrences in Sackett, then we're in a whole nother area, and query if that's good for separation of powers if you've got the court essentially repealing the constitutional basis for laws that have been on the books for more than half a century.
Yeah, I was about to make a joke that we're working right now on a strategic litigation plan to implement that concurrence. No, I think the reality is, and as Professor Percival noted, the Endangered Species Act is a great example. Chief Justice Roberts, when he was on the D.C. Circuit, had that dissental where he talked about the hapless toad, and people thought, oh, well, maybe he's going to bring some Commerce Clause circumspection to environmental law. It hasn't really worked out that way. I think the Supreme Court's been petitioned a half dozen times on the Endangered Species Act and its Commerce Clause connection, and it's denied cert. So I think if there is going to be a change when it comes to Commerce Clause and the environmental law, it will be indirect, meaning the court will decide something outside of environmental law, whether it's healthcare and NFIB or in the criminal law context in Lopez and Morrison. And then in the lower courts, it might be applied analogously to environmental law. But I don't think the court currently is ready to entertain positively that direct attack.
I'm glad to hear you say that.
Well, can we give the panelists a warm thank you? Thank you for doing this.